Welcome back. We continue with privacy torts. Today we take up appropriation. Appropriation is when you take an attribute of the plaintiff's personality and use it for commercial purposes. Most often it's accomplished through the use of photos, but it can also be accomplished through the use of unique identifying characteristics of the plaintiff. And of course, something must be marketed or sold. In Bosley versus WildWet.com, Catherine Bosley, an anchor and reporter at a CBS local station, was on vacation. She took part in a wet t-shirt competition at a nightclub. The nightclub owner videotaped her in various stages of undress. Shortly thereafter, the video started to appear on the net. Ms. Bosley lost her job on television. And she soon discovered that her video was being used by WildWet.com. Now, the people who simply posted video of Miss Bosley had no appropriation problems. They weren't selling anything. But WildWet.com showed her video and offered to show viewers even more if they would purchase premium membership. So the selling of the premium membership using her video was a commercial purpose. Not everything is going to be commercial purpose. Time versus Time Warner. Frederick Younger's A Perfect Storm made into a movie of the same name, starring George Clooney and several other people, was the subject of an appropriation lawsuit. Captain Billy Tynes' family sued, saying that Time Warner appropriated his likeness for the film. The courts in Florida held that making a movie is not a commercial purpose unless the movie is being used to sell something. Just simply making money from ticket sales or promoting the movie are not commercial purposes. Now, qualifying appropriation as being something where the movie would be used to sell something doesn't mean product placement. It means that the movie is actually making a pitch to purchase a particular product. If it were simply a matter of product placement, pretty much every movie and television show would be a commercial purpose. News, of course, is not a commercial purpose. But being used to market stuff, well, that is commercial purpose. The elements of appropriation: publication, people have to see it, especially the person whose likeness is being used. Identification, it has to be of and concerning the plaintiff. We have an interesting story about the novel From Here to Eternity. Here to Eternity features a character by the name of Angelo Maggio. After the book came out, Angelo Maggio, a resident of Brooklyn, New York, sued, claiming that his name had been appropriated for the novel. The courts quickly dismissed the case, saying that although the names were the same, there was no identification between Angelo Maggio, the literary creation, and Angelo Maggio, the Brooklynite. And of course, the third element of appropriation is commercial use. One of the cases we deal with is Kerby versus Roach Studios, and this may be a little difficult to understand in light of the Maggio versus Charles Scribner's and Son. But Roach Studios was a movie company in the previous century. They had made a number of what were called madcap whirlwind comedies in the 1930s. One of the comedies was a film called Topper, which had some sequels. One of the characters in Topper was named Marion Kerby. She was a ghost. In the movie Topper, ghosts help a man navigate the hazards of life. This predates the internet. This predates national television, satellite, cable, whatever. And the studio needed to promote the movie, but they weren't sure how they might be able to get buzz going. So they hit upon a plan where they sent 100 perfumed letters to single men in the Los Angeles area. The letters were signed your ectoplasmic playmate, Marion Kerby. And the idea was these guys would get these perfumed letters, which suggested that they get together with Miss Kerby and explore fun and wild times, and that they would then start to talk about Miss Kerby with their friends. When Topper came out and the theater billboards made reference to Marion Kerby, other people would say, oh, Marion Kerby, that's the girl who sent Bob a perfumed letter. And it would generate buzz and people would want to go see the movie. It kind of worked, but it had an unintended consequence. It turns out there was a real-life Marion Kerby in the Los Angeles area. And after the letters went out, she began getting phone calls from men who said, I received your letter. I'm definitely interested in getting together with you. She found a letter. She got a letter from one of the men. She sued Hal Roach Studios. And the court there held that Hal Roach had appropriated her identity for the promotion of its film. It was selling the movie to the public. It wasn't a matter of the movie selling something. Now, you might say, well, Angelo Maggio didn't get any relief over From Here to Eternity. The difference is Marion Kerby was the only Marion Kerby in the LA area, the place where the publication took place. And people identified her as the sender of the perfumed letter. So be careful about that. Today, it would be difficult to simply say a character in a movie is whoever you claim to be. We have too large an audience, too broad a footprint for the advertising. Right of publicity is associated with this. Right of publicity, unlike appropriation, is for people who have achieved a certain fame or notoriety. These famous people have the right to control how, where, and when their notoriety is used to sell something. Our first case, Zacchini versus Scripps-Howard. This is a case from midway in the previous century. Hugo, the human cannonball Zacchini, is a performer. He's performing at a state fair. As you might guess, his act is being shot out of a cannon. A news crew from a Scripps-Howard owned local station goes out to the fair to do a story about the acts and the attractions that people will be able to look at. They interview Mr. Zacchini, and they also film him. Now, he says he's fine with the interview and the filming, but he says, you can't show me being shot out of a cannon. That's the whole point of selling tickets. If people can see me being shot out of a cannon on TV, they won't buy a ticket. Well, sure as shooting, the Scripps-Howard TV station did a story on the fair, and they showed 15 seconds of Mr. Zacchini being shot out of a cannon. He sued. State courts rejected his claim. They sided with the TV station. But the United States Supreme Court went the other way. They sided with Mr. Zacchini. And they explained it this way. When the television station showed his act, the climax of his act, him being shot out of a cannon, they essentially were showing his entire act, the thing that people paid money to see. And they didn't have a right to do that. Mr. Zacchini had the right to control and protect his act in order to keep making money. Baseball card cases, if you are in the bigs, then you would be approached by people making and selling baseball cards. Used to be that baseball cards would come with chewing gum, little flat sheet of chewing gum, sharp enough to cut you, but it came with baseball cards. When a baseball player sells his right of publicity to a baseball card company, he is giving them exclusive access to be able to use his name, his picture, his stats as they sell these cards. Nobody else can do that. Fame after death. Lugosi versus Universal Pictures. Bela Lugosi, a star of the 1920s and 30s, most famously known as Dracula. When I was a student in the previous century, many decades after Dracula came out, Lugosi's image became a staple of dorm and apartment decorating. You'd go into a dorm or an apartment, you'd see this large poster of Lugosi as Dracula, with a cape around his arm, his eyes peering at you. There were also ashtrays, candles holders. And Universal Pictures is making money off the trade. Lugosi, of course, has died. His widow and his son sued Universal Pictures, saying, "You're making money off the fame of my husband. We deserve a part of that." They go to court, and the courts hold that Lugosi had to have established that right of publicity before his death to be able to enforce it against Universal Pictures. And because Lugosi, at the time that he died, was not a popular icon, and he was not selling posters and ashtrays and candle holders, he had not established that right. So the widow and son were denied any relief in their right of publicity claim. We have two cases out of Tennessee involving the king, Elvis Presley. Essentially, the upshot is this. Tennessee concludes that there may be a right of publicity, but it is short-lived. In fact, the Tennessee legislature codifies this idea, saying that for 10 years after a celebrity's death, the estate can control the right of publicity. After that 10-year period, then there is no more right of publicity, and anybody can use the celebrity's likeness for commercial purposes. California is a little different. California statute protects California residents, which is why a lot of people in the entertainment business still have residences in California. They claim California as their state of residence. That's because California pretty much gives the estates of those celebrities control over the right of publicity. That's an important thing. If you have seen any commercials featuring the likeness of Marilyn Monroe, that was done with the permission and after compensating the Monroe estate. It's an attractive feature. Defenses for appropriation. Well, there's consent. I consented to be used to sell your product or service. Newsworthiness. Well, remember, news is not a commercial purpose, and so if it's a news item, then it can't be appropriation, and that's it. Consent, again, must be effective and valid. Newsworthiness is judged on a case-by-case basis. Anne Margaret versus High Society. Anne Margaret, an entertainer who was in her prime in the previous century. She appeared in a movie in which she was topless. High Society, a skin magazine, ran a story on her being topless and took stills from the movie in its pages. Anne Margaret sued, claiming a right of publicity. The judge in the case, rightfully or wrongfully, actually I don't agree with his reasoning in this, said that Anne Margaret was the subject of many male fantasies when she was in her prime, and so the fact that she was appearing at least topless in a movie was newsworthy, at least to those guys. And he concluded that it was not appropriation. Let's move on to private facts. And the tort is more correctly known as publication of private matters that violate the ordinary decencies of privacy. We all have secrets. We've either done things or have had things done to us that we would not want anybody else to know about. This tort protected those secrets for quite some time. Although when we get further into this, I will tell you why I don't think it's really viable anymore. The elements of private facts, of course, publication, identification, disclosure of private facts. Barber versus time. We're going to see Miss Barber twice in the section on privacy. She had a condition. The condition revved up her metabolism to the point that she ate all the time and she was still losing weight. This was a secret for her. She didn't want it publicly disclosed. She didn't want to be seen as a geek or a freak. A freelance photographer learned about Miss Barber. At the time he learned about her, she had gotten so weak from being unable to maintain calorie intake with calorie output that she was hospitalized. He got into the hospital, found her room, went inside, and took photos of her. He sold the photos to Life magazine, which is published by Time Inc. And Life magazine did a story on the starving glutton, making reference to the fact that she was eating all the time and she was still losing weight. Miss Barber sued under private facts, and the courts agreed with her, saying this is not something generally known, and people have the right to keep their conditions private. And she wins the case. We're going to see her again when we get into intrusion, but for private facts, here we are. Sipple versus Chronicle Publishing. Gerald Ford was the subject of several assassination attempts, one of which took place in California in San Francisco. He was in San Francisco making a presentation, giving a speech. Oliver Sipple was in the crowd watching him when he noticed a handgun pushing past him. So he grabbed the hand holding the handgun, wrestled the young woman who had the pistol until Secret Service agents converged and wrestled her to the ground and took her into custody. That was great. Sipple was kind of a hero. A columnist, shortly after his heroics, did a column in which he talked about the fact that Sipple was gay. Now, you have to understand that this is more than 40 years ago, when being gay or being called gay was something that could damage your reputation and get you punched in the nose. Sipple sued the newspaper and its publishing company, saying that his sexual orientation was a private fact. It went through the courts, and ultimately the courts held that, yes, Mr. Sipple's sexual orientation was a private matter, but, the court held, there was interest in his heroism. And his heroism that he demonstrated was quite unlike the stereotyping of gay men. At that time, the general public held a number of stereotypes about gay men, one of which was that in times of crisis or emergency, that they would shriek and faint or be unable to take decisive action. Mr. Sipple showed that that wasn't true. And so the courts held there was sufficient public interest, it was newsworthy enough, that his privacy rights had to give way to the public interest. Diaz versus Oakland Tribune. Tony Diaz had been elected president of the student body at a community college in Oakland, California. A columnist for the Oakland Tribune ran a column one day in which he, in a snarky tone, talked about Tony Diaz and revealed to the world that Tony Diaz had been born Antonio Diaz and had had a sex change. Ms. Diaz sued the Tribune. She won her case. The fact that she had gender reassignment was not a matter of public interest. She prevailed. The jury found in her favor. The case was appealed. The appellate courts looked at whether or not there had been a sufficient examination of the newsworthiness of her gender reassignment, and so they ordered the case to be tried again. At that time, Ms. Diaz and the Oakland Tribune entered into a settlement, and so the case was dismissed. Defenses to private facts: 1, it's in the public record. 2, newsworthiness, as we've seen in the Sipple case and the Diaz case. And 3, consent. Howard versus Des Moines Register. This is an interesting case, and it demonstrates one of the big changes between then and now. It used to be that if you were a girl and you were a teenager going into high school, and you were kind of a wild child, at one point in time, your family could take you down to a medical clinic and get you fixed. That is to say, have your reproductive parts removed, give you a hysterectomy, in order to avoid scandal and the public shame that a family would feel at a daughter who got knocked up, or pregnant, if you will. The Des Moines Register did a story about a period of time in which this had happened, and it's within living memory. And they told the story of a teenage daughter who'd been taken down to a clinic and been sterilized at the insistence of her family to avoid the possibility of an unplanned pregnancy. They checked the directory to see if she still lived in the area, and they checked under her maiden name. That's as far as they went. Mrs. Howard had a different last name because she married. Now, why the Des Moines Register didn't look at their wedding announcements to see if the young woman with the maiden name had turned into Mrs. Howard, I don't know. They probably just forgot to do that. She sued, alleging private facts. And her argument was this: is that I was, taken to this clinic, I was strapped down, they put me under, I didn't have the ability, I didn't have the power to stop them from sterilizing me, and I've had to live with the fact that this was done to me for the rest of my life. In this case, the trial court judge held that, yes, it was a private fact, but, he said, the private fact was outweighed by consideration of the fact that using her real name lent the story more credibility. Again, this is one of the cases where I simply disagree with the judge's reasoning, but the judge ruled I didn't, and so Mrs. Howard lost her case. Everybody found out about it. No one had known why she and her husband hadn't had children.